Mr. Dorfman, we were just talking about the effect that a pleaded jurisdiction actually has on the discovery in the case. Now, I want to focus, Eric, if you wouldn't mind focusing on the next page, top paragraph, which is the bottom paragraph of Article, bottom paragraph of Article 8. I want to read that to you. Testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Now, throughout the course of the lawsuit that the whistleblowers filed, are you aware of whether specific facts or allegations became public? And could you turn your mic on, sir? Better? Okay, I'm going to re-ask that question.
Please.
Were you aware of whether the specific facts or allegations with regard to the whistleblower suit became public?
Yes.
Can you tell us about in which ways, if you know, they became public?
Well, we talked about that earlier before I came to interview at the office. There were news stories that contained allegations made by the whistleblowers. It was about that same time, maybe a little later, that the lawsuit was filed. That was a news story and a very detailed state court petition that's public record, public filing, covered in the press accounts. And then I think they amended that petition twice between the original filing and early February. So there was a first amended maybe in December, and then in February, just before the plea of the jurisdiction hearing and the temporary injunction hearing, they filed a second amended petition, which I think is the last one. But that's 63 pages, very detailed allegations.
And I'm going to stop you real quick just to clarify. When you say they filed and amended petitions, can you talk to us a little bit about, well, who filed those petitions?
The four plaintiffs through their lawyers.
So David Maxwell, Mark Penley, Ryan Vassar, and Blake Brickman?
Yes.
And did those petitions include specific facts that they were alleging
Yes.
Attorney General Paxton and the Office of Attorney General committed?
Yes.
Okay. And those pleadings were actually available to the public, correct?
Yes.
You can look them up online?
Yes.
Okay. So, Eric, if you don't mind going back one page to the bottom paragraph, bottom clause. Article 8 alleges that Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that allegation true?
No. Can I explain?
Please do.
The settlement agreement didn't stay the wrongful termination suit. It was on appeal, and our petition for review was pending with the Supreme Court of Texas. That court doesn't have to take any case it doesn't want to, so you have to convince it to take the case. We had made a case. Filed 2 briefs to do that.
I'm going to stop you because we're going to get there, and I want to break that down.
Sorry.
But with regard to conspicuously delaying the discovery of facts,
the settlement agreement didn't do that.
And weren't the facts available to the public at this point anyway?
More than we discussed. Obviously, the petitions I mentioned, but the Court of Appeals decision is 30 pages and has bullet point block paragraph recitals from the pleadings. Mm-hmm. So it was restated the most serious allegations that the complaints, the petitions made, were restated in the Court of Appeals decision, which also garnered news attention when it came out.